can lie. Alibis get swept aside. I got proof that can't be denied. The data don't lie, people do. Waves crashing, secrets in the tide. Facts and numbers side by side. Through the chaos I will abide. The data don't lie, people do. Look at the records, feel the vibe. Digits and bytes come alive. I stand tall with nothing to hide. The data don't lie, people do. May twist and tongues may tie. Plausible tales shape the sky. In the end you can verify. The data don't lie, people do. It's in the matrix beyond the eye. Hard truth that's flying by. Evidence you can't defy. The data don't lie, people do. Look at the records, feel the vibe. Digits and bytes come alive. I stand tall with nothing to hide. The data don't lie, people do. Digits and bytes come alive. I stand tall with nothing to hide. The data don't lie, people do.
Hello everybody. How are we all? Are we all suitably pissed off with Norfolk County today? Hello Bradley, time to pause Candace. I didn't know she had a show on. Alright, I watched it. What are we all doing? Happy Monday to everyone on the north side of the equator, and happy Tuesday to everyone on the south side. I think that's how it works. It might actually be left and right, like east and west. I forget. Don't break my brain today because I haven't slept all fucking night. I stayed awake all night because I thought I'm just going to miss the stream if I don't. So, yeah, so I'm a little croaky, a little tired. Probably need a cigarette and another coffee. So thanks for posting those links to me, Kevy. Supermod. Michelle's not here to argue with you. She's at work. So you can be Supermod without her bitching at you today. Thanks for those links. Just scrolling back. Okay. Betero and Aiden after court. Let's do that one. I'm going to open with that anyway, but Kevy's just link after link after link after link, but we're not going to do bricks and minifigs today. Just going to cover the frustrating shit we watched in court. Everyone seems to be suitably pissed off with it. But it's to be expected. Like, this is the way I see it. A lot of viewers are looking at each of these cases in a bubble. But what they don't seem to be putting together is when you are fighting, when you're up against the entire state apparatus, then shit's going to all start like melding together, which is what we're seeing here. We've got judges in every single courtroom don't want to dismiss, even though in many cases they absolutely have to. So I'm going to cross over into the Karen Reid anti-slap motions, talk about how that's connected to the way we saw Judge, what's his name again? Belazos behaving today. No Lego today, Irish. Sorry. No Lego today. I've got sore feet from the Lego. So yeah, I've got a whole bunch of shit to tie this all together. So when you're up against the entire state apparatus, you have to expect that nothing's going to be in a vacuum. You can look at Aiden's judge, which I'm sure he did, and go, he seems all right. Maybe we got the good guy. But it's the state apparatus still, right? Judges are still the state apparatus. They're either appointed by the state or voted by the people of the state. Most places are appointed by the state. So they're still part of the state apparatus. And if that's what you're going after, which we know Karen Read is, I don't know that Turtle Boy is yet. I'm sure he will. I'm sure eventually there's going to be a financial incentive for him to go after the state. Right now, he's got to get himself off the I'm going to jail for 660 years hook. But I'm sure he's getting there. Judges need trials to increase their salaries. Yes, Bradley. And it's a racket, for sure. For sure. But they're also going to protect the state because that's where their salaries come from, right? The taxpayers pay the state, and then the state pays the judges. So they need to protect the state so that the state continues to have, court cases. So I'm not surprised at all. I know what the judge's decision is already. And this is the thing. They are all doing the same thing. They are all trying to find loopholes to make all of these cases survive. In the anti-SLAPP motions, you've seen multiple cases get dismissed at this level, at this stage of the game, multiple times. I'm just trying to think of the ones that come to mind. There was a case against Tucker Carlson, and I forget who it was sued Tucker Carlson, but that got knocked down at the SLAPP dismissal stage because he had, like Aiden, has his own personality and his own show, and he's doing his own thing, even though it was on the Fox News channel. The anti-SLAPP in that state was the final say in the matter because people don't tune in to Tucker Carlson for actually news. People tune in because they want his opinion on stuff. Same with Rachel Maddow. You can love or hate either of these two characters, and I don't like mainstream media at all. I'm glad that Tucker got out of it. He seems to be one of the sane ones, I guess, but I don't think you can call Rachel Maddow sane. But that's just my personal opinion. Anyway, she also won hers, and hers was based on, nobody tunes into Rachel Maddow for news. She's not real news. And it's the same thing. It's a personality sort of opinion show. So, so we know that that's, some of the standards for anti-SLAPP, but each state's got its own anti-SLAPP law and how it applies. And Massachusetts just changed theirs. So, we kind of know by default that the new anti-SLAPP law, the Bristol Asphalt Standard, Rachel Madcow, that's the one. This is what I'm talking about. By the Bristol Asphalt Standard, it's straight up, two questions. Was it petitioning? And did it have a lawful or factual basis? That's it. It's two questions now. And so we can see Gildea reach in any direction that he fucking can to try and make the case go forward. So Irish outsider, former Playboy model Karen McDougal sued Fox and Tucker Carlson for defamation after Carlson stated on his shows that she had extorted Donald Trump over an alleged affair. That's the one. Older than dirt, good to see you. Your front and your back too. The lawsuit was dismissed after Fox's legal defense successfully argued that the federal judge agreed that Carlson's commentary constituted non-actionable opinion and exaggeration and rhetorical hyperbole rather than statements of actual fact, and that no reasonable viewer would take his show's commentary as literal factual reporting. Right. And that's the same thing with Aidan Carney, but he kind of undoes his own argument there because he wants to be taken as a serious factual reporter. And there's two different sides. There's two different sides to Aidan Carney. There's his show, the YouTube channel, which is not his reporting, and then there's his actual reporting. On his Turtle Boy Daily News. So two completely different people. You don't see him talking about jubble and boobies on his blog, right? So paste the Mad Cow one in, Kebby, because I'm pretty sure in that one they said she's not real news or something. I can't even remember what it was. Hers was actually a funny one, but it came to the same conclusion, and I think probably even the same state anti-slap. But let me show you this. Let me show you this interesting. I put a video out about this, but I literally was quoting Finney Sheehan, which is Sheehan Finney, sorry. Princey's in the house. Oh no, you got shuffled down to second mod and now Princey super mod. Kebby. Let me share this screen. Oh, this is going to make a noise again. Hang on a second. Sorry, guys. Whenever I switch back to this screen, if I don't stop the sharing, it kicks that off again. All right. Shut that off. Shut up. No. Remove it. Oh, good night. Don't go. Don't leave us, Kerry. I'll pay you to stay. All right. For those of you who are on phones tonight, you'll notice I'm actually streaming in a phone-friendly format as well tonight. Well, it's morning here, but you get what I'm saying. So this is actually the Boston Bar saying the same thing. So essentially, they're telling us that Bristol Asphalt is the new anti slap. They're calling it the simplified anti. I don't know why I'm tongue tied, probably because I didn't sleep, but simplified anti-slap framework. So the background was like the new framework creates a two-stage analysis of special motions to dismiss. The proponent of a special motion to dismiss has a threshold of establishing that the claims against it are based on its petitioning activity. If this burden is met, the special motion to dismiss must be granted unless the opponent demonstrates, that is the plaintiffs in this case, sorry, that the that the proponent's exercise of its rights to petition was devoid of any reasonable factual support or any arguable basis in law and caused actual injury. So that's it. 2 questions. Not all the questions Gilday was asking. Like, he was trying to pass out Karen's, like most of the lawyers, commentators have been saying, pass out the Terry Muir statements as something separate to their petitioning activity. You can't do that anymore. Under this statute, you can't do that anymore. So the SJC first interpreted the anti-SLAPP statute in Duracraft, holding that the state's words based on meant the proponent of the special motion to dismiss must show that the claims against it are based on its petitioning activities alone and have no substantial basis other than or in addition to the petitioning activities. Sorry guys, I'm reading really badly today because, like I said, I haven't had any sleep. So the SJC explained that its interpretation of based on should serve to distinguish meritless from meritorious claims and was intended by the legislature. So for close to 20 years, Duracraft remained the standard applicable to special motions to dismiss until Blanchard excuse me, Blanchard introduced changes to both the first and second stages of the special motion to dismiss analysis. At the first stage, Blanchard permitted the passing of claims, like separating this one can be petitioning but that one can't, which were based on both petitioning and non-petitioning activity. To the extent that a claim was based on petitioning activity, the special motion to dismiss would be denied. Sorry, on a non-petitioning activity, it would be denied. The portion of the claim based on petitioning activity would be evaluated at the second stage. So we did hear Judge Gilday asking questions about what was going to be petitioning and what was non-petitioning, and we also heard the plaintiffs argue that some of Karen Reid's actions were not petitioning. But that's the Blanchard rule. So, and then that second branch, Blanchard added an alternative path for special motion opponent to avoid dismissal of its claims. So the opponent, not the proponent, applying for it. So in the Bristol Asphalt, the SJC reiterated its concern that because the anti-SLAPP statute does not provide an opportunity for the opponent of a special motion to dismiss to show that its own claims are not frivolous or, revenge, which is what this is, the special motion opponent's constitutional right to petition is infringed. So that's under the old Blanchard. That's what would happen. Bristol Asphalt. Oh, sorry, that's just quoting Bristol Asphalt. They put their full stops all in the wrong places. The tension between the exercise of the right to petition by both the proponent and the opponent of the special motion to dismiss gives rise to a constitutional problem paradox. The SJC's interpretation of the words based on in Duracraft and Blanchard was intended to resolve this tension and protect the parties' respective First Amendment rights. The SJC acknowledged in Bristol Asphalt that the Blanchard analysis had proven to be overly complicated and time-consuming. Therefore, they changed it. So in the new Bristol Asphalt ruling, it's now 2 questions. Was it plain and simply petitioning, and did it have a factual basis? That's it. So I know that Judge Gilday is familiar with the new changes because when that hearing first opened, it was the first thing he said. He basically read out the Bristol Asphalt statute standards. He also agreed when can't think of his name for some reason. Was it Seligson? Yes. As soon as Seligson said, we aren't obligated to list every single argument that they've made, the judge very quickly interrupted and said, well, I know you're not. But then he threw in a Bristol Asphalt sort of slant to what he was saying, and then he turned it into an insult and decided that there was a procedural prejudice. There's no such thing as a procedural prejudice. There's only prejudice to one party or the other, not fucking procedural prejudice. But anyway, so he's doing the very same thing, like fishing for all the ways around this, that, and the other in these new anti-slap laws, as Balazos was trying to do today. So in all of the cases, I see all of the judges struggling to get around, like, to make these cases stay alive. They're trying to get around everything they can, despite the fact that there's a lot of evidence being presented by Karen's team and Carney's team that there's a lot of corruption going on here. But they're all trying to skirt around the law, basically, in the same sort of ways. And it's because they're trying to protect the state. It's quite obvious that they're trying to protect the state. They need to keep them alive. They've been given their marching orders. They have to find a way to keep it alive. So in today's hearing, I thought Bettero coming straight out the gate with appeals court rulings was a very strong sort of indicator that if Balazos is going to farfo, he's going to fo. Basically, that's kind of what I read into that. Generally, you would leave those sort of arguments like till the last bit, I guess. But he just came straight out the gate firing on the Odell motion, and I guess it's a motion to dismiss, so you want to come out the gate firing. But the fact that he was just focusing on the appeals side of everything, and he said appeals so many times, I thought that was a very strong, straight out the gate sort of intentional, if you fuck us around, we're going to go to appeals kind of deal, which is good. It's good. It's good to see the fight. And I like to see Bettero all fired up and feisty. And I kind of felt that the judge sort of showed his hand a little bit there. So what we do notice with every single judge is they're always coming down on the defense or the defendants or their legal teams, but they're not doing that to the state. So what happened today was Cozzy Bear got up and said a whole bunch of shit that had my jaw on the floor. I was like, is he really saying that in court on the record? So Bettero points out that, you know, they've been caught red-handed laundering video titles and videos to the grand jury. Like, they didn't just show the full streams, they just showed them the edited clips to manufacture intent and put it in a folder called intent and gave it to the jury as in a folder called intent. So so what did Balazos do? You know, he hides behind the SJC, and he's basically arguing that if the prosecutor lied by omission to get the indictment, oh well, Who cares? Oh well. So that was kind of one example of the state machinery in action there, and how Belazos is part of that machinery trying to make this case stay alive. So the next thing I think was the anatomy twist. The anatomy twist was Bettero isn't just arguing that the police didn't just present a weak case to the grand jury. He's arguing that they actively manipulated the narrative. And that's a pretty straightforward Odell kind of motion, I think. I think that's the Odell part. So by feeding the grand jury cherry-picked YouTube statements and stripping the context of those messages and including the names of the titles of the videos, the investigators created, what would you say, an artificial version of reality just to secure the indictment. That's the way I read it. I better look at comments in case someone here is disagreeing with me. Here for the venting, Lozzie. um, all right. Comments are done. Feel free to disagree with me. I'm just venting and throwing this all in the ether, okay? So so they didn't let the grand jury act as independent fact finders. They pretty much, by doing things the way they did, they just turned them into rubber stamps. So then Belazos is pushing back, and he's like trying to outsmart Bettero on the law, on the case law, which was pretty funny because he was still arguing really weak points. It was actually really hard to hear what he was arguing. I'll be honest with that. It was very difficult. I had to play it back a few times to actually hear what he was saying. But yeah, he's pushing back on Bettero. Yeah, he's a judge. You probably should know these laws, these case laws better than Bettero, but clearly he didn't. Bettero is very strong on his knowledge of those particular citations. So I just got the feeling that Belazos was trying to find like minor loopholes in Bettero's like citations, and he's using semantic arguments to claim that the police's twisting was just a standard interpretation rather than a deliberate fraud on the court. It was just trying to twist it around so that it obviously he's aiming for it to survive, isn't he? So that pissed me off. Did that piss you guys off, the way he was doing that? I found it very annoying. It's like the citation is the citation, and unless you are incorrectly citing it, then yes, you probably have an argument to make, but he wasn't incorrectly citing it. And Belazos couldn't really put a finger on how to twist it because he wasn't, because Bettero was doing a very good job of citing it correctly. So I got the impression that he's trying to create like a clean court record so that when he inevitably denies the motion to dismiss, which he's obviously going to do, and tries to kick the can down the road again, his decision looks like, careful judicial analysis instead of systemic protection. So that was the impression I got from the interaction between Bettero and the and the judge. So I just didn't feel like Belezos was outraged enough by the police misconduct. Like he didn't believe it. But I mean, fuck, how much evidence do you need? They have all of this backed up with evidence. So the devil's work it is. Yes, Bradley. Indeed it is. Yes, Harley, you can hear birdies because it's early in the morning here. Well, it's 9:30 now, but it's morning here. So the rolling rally was another thing that pissed me off because, I mean, quite clearly the judge shouldn't even be considering anything to do with the rolling rally because it was protesting. Just because you're in a car doesn't mean you're not protesting. So it really pissed me off with that stuff. So I got a little frustrated because I don't quite understand. I thought Aidan Carney was charged, like I thought he was charged for the rolling rally stuff, like harassing, like the houses claim that he was harassing them because he went to their houses, even though he stayed on the street and he stayed on the sidewalk and everybody did, which is a public space. They still claimed that he was harassing them. So I thought that he did get indicted for those things. So I'm a little confused because what I heard today was like they secured an indictment for behavior A, right? Which is all the YouTube clips. But then unilaterally changed rules later by trying to convict him for behavior B, the rolling rally. But then today it doesn't sound like he actually was. Like that's what all unfolded during the whole process, but it doesn't sound like he actually was indicted for the rolling rally stuff or charged. So that I'm confused about that. It seems like it was construction of, let's just get him for anything and see what sticks. That's what that seemed like to me. So I'm still a little confused what he's actually like. I know there's 16 counts of witness intimidation. TB couldn't figure out he was harassing empty homes. Right. So I'm thinking that maybe the prosecutors hid the rolling rally from the grand jury because, it's textbook protected First Amendment expression. And then, played around with how they were going to use that with the 16 charges that he's got of witness intimidation. So I think that could be the case because the jury's not going to indict him on, protesting in a car. I think they indicted him for any and everything he has done in regard to FKR, basically throwing everything at her, at the wall to see what will stick. That's what I think too. Was he? So I don't know. I tend to, when I'm researching, I'm looking at the black letter law, right? What's written on the paper. These guys aren't playing those rules, right? They know what the black letter of the law is, but they aren't going to follow it. They're going to find any loophole that they think they can get away with at the appeals level. Any loophole. They're just going to fiddle their way around it. So Balazos and Gilday are both going to, this is my prediction, they're both going to rule on procedural prejudice, to quote Gilday, to quote Uncle Bev. So that gets him around the anti-statute. That's the anti-SLAPP statute. He's not making a ruling on that. He's just going to make a procedural ruling. And then I think Balazos is going to do something similar because he was up Bettero's ass about procedure as well. Like, why have I got 2 dismissals here? Well, one's an Odell and the other one's dismissal for egregious government misconduct. He's like, I want a better motion in front of me. That doesn't answer any of the questions. That's just a procedural stick up his ass. Same as Uncle Bev. So it reminded me of the Sovereign Citizens Playbook. Use semantics to alter the law's intent to fit your needs. Yeah, that's a good point, Lozzie. And they'd be the first ones to friggin' bitch about having yourself sit in their courtroom claiming that shit. Meanwhile, that's exactly what they're doing. You're right. You're exactly right. So, Melanie made a good point today about, Aiden's facing 160 years in jail and he's worried about fucking paperwork. Your paperwork's not good enough. So Balazos' comments about the rolling rally was just a desperate attempt to surgically sever the state's constitutional overreach from the official record, which is what we see Uncle Bev doing as well, trying to sever the Terry Muir statements from petitioning activity so that the claims can survive. So they're all using the same playbook, basically, to get around very valid dismissal cases. So put it this way. If Balazos ruled on the anti-SLAPP, okay, both of those, that's all dismissed. There's not going to be any appeals that anyone can win because there was a factual basis for it and they were petitioning. End of story. So that's not a risk of appeal for him. And that's it. It's over. Move on. The wrongful death is probably a different thing again because, that involves the family and you got all the feels and all the stuff involved with that. So the defamation, there's definitely no appeal avenue that the defendant, that the plaintiffs can make there that would overturn Uncle Bev. Same thing with this case against Turtle Boy. If that was dismissed today, like if he just said, all right, look, you guys, you did a really bad job with the grand jury, the Odell motion is legit, we're ruling on it right now, there wouldn't really be an appeals avenue for the state in that because the Odell motion is the ruling, is the black and white letter of the law. So neither of them are risking anything. They're not risking being overturned. They're not risking their jobs. They're not risking being told they're wrong. That's not the case in the wrongful death. I think the wrongful death, because of all the feels and everything involved with that, I think that one actually does have to go to trial. And I think Karen's ready to fight that one. I also think Karen's ready to fight Gilday. And I'm going to get to that because there's only 2 ways she can go from this point, from this anti-SLAPP point. And there is a third way, but it's not a good way. The other 2 ways are good. Well, the other 2 ways are better for her, but one of them is best. And I'll get to that in a minute. Because I'm still trying to sort of show you that no matter which one we're looking at, no matter which court we're looking at here in Norfolk County, they're all doing the same thing. They're either kicking the can down the road, trying not to answer any of the motions, and delay, or they are at the point where they've got no choice. They have to make some rulings because they've already delayed too long, and they're trying to find procedural reasons to make sure that the cases survive. It's happening in all of the cases, except for Casper's court. And I actually have a little bit of faith in Casper, not because I know anything about Judge Casper, but she's definitely a reformer. From what I can tell in her judicial history, she's into law reform. But then again, so was Arnie Bev, so that doesn't mean much in the grand scheme. But she's definitely a reformer, and she's definitely a civil rights advocate. And she's definitely a stickler for the federal rules. So I kind of feel like she might be a little different, but we've got our hopes up before. But she's not in Norfolk County necessarily, so that's another plus. So I kind of feel like right now she's still like outside of this little racket trying to protect the state. But she's the only one that is. The rest of them are all in this as thick as fucking thieves. So then I think Bederoe, back to Bederoe, he ends up in Rule 14 violations sort of area, right? Where, they still haven't even got their discovery from anybody, which was supposed to be done like months and months ago. So that turns into another boxing match with the judge. Like, he knows Rule 14. He knows that one backwards. Come on, stop arguing about Rule 14. All right? They didn't hand over the discovery. They took it to the grand jury. And then they're starting this fight here. And they're not even handing over, the evidence that they need. So they've got partial email exchanges between different people. They haven't got all of the email exchanges. They've got partial text messages between the individuals. They don't have all of the text messages. So there's withholding of evidence and Brady violations going on leading up to the dismissal. So I saw the judge doing a lot of pivoting and twisting of that subject, and some of them are just pretty straightforward. Most of the things that Bederoe is pointing out are pretty straightforward. Then I think they go back to conversations about, what was shown to the grand jury, because that's part of the hiding the evidence things. So they didn't show the grand jury all of the information either, because the grand jury they're not supposed to just show the incriminating evidence. They're supposed to be a neutral. The prosecutors are supposed to be in good faith and neutral, but they didn't do that. So they are, hello, Big Pork Chop. They are delaying and prolonging so that the time to charge manslaughter has passed. I'm not sure, to be honest. I know murder has no statute of limitations. I don't know about manslaughter, but you could be right there. Hey, Goldfish. How's it hanging, dude? So yeah. So that's kind of that's kind of where I'm at with the Lazos's gaslighting in court today. Anybody else feel like they were gaslit by him? So it was kind of like he was playing a desperate game of divide and conquer. That was my impression. So he's trying to compartmentalize the case to death as much as he possibly can. He's trying to defend Kate Peter, even though he asked both sides, what's the go with Kate Peter. He was still kind of defending it like, you don't have enough evidence to prove that she was a state actor, do you? So I thought, excuse me, I thought Betterow argued that very strongly. And then they had a hang on, soliloquy is what I was after, about upcoming hearings. What are we doing? I need you guys to meet and confer and do this and do that and blah, blah, blah. And we need this done. We need that done. So that kind of told me he's already ruled, right? There's not going to be a dismissal. The way he battled Betterow and then the way that everything ended up at the end there, that goose is cooked. There is not going to be a dismissal, which is exactly what he wanted. So let's now go back. Let's go back to... So I'm looking through my notes, okay? Oh, that's right. Alan Jackson ripping on Cosgrove. That was bloody good. All right. That one didn't piss me off. Two things. The judge didn't piss me off for a change. That was a Doolan, wasn't it? Usually he is pissing me off, but he actually didn't piss me off this time. Heard a bit of Betterow's argument and he spoke very well. Yes. I was like in awe of AJ. There's certain moments through the trial where he just came out like guns are blazing. We see this feisty side of him, and Bev calmed him down quite a lot. Like she took that edge off quite a few times. But that's a side of Alan Jackson I actually like to see, and he let both barrels. He let him have both barrels in that motion over Karen's phones. But the thing that pisses me off about the phones is, and I've bitched about this before, you'll know I have, that they already held the grand jury to try and indict Karen and Aiden for conspiracy in witness intimidation. Or witness intimidation conspiracy. I don't even know how if I can say it, but you get where I'm going. They had that back in, what was it, 2023? June or July 2023. And the grand jury declined to indict them. And then after that, they then go to, and I think it started with Krupp. It was once in front of Krupp, and he didn't rule on it. And then it was put in front of Doolan. Oh, we need a taint team on Aiden Carney's phones. It's like, what the fuck? It's already fruit of the poisonous tree. It's already been used in the grand jury to try and indict him. How can you now launder that, make it look clean again, and say, oh yeah, we just need a taint team and it's all clean, it's all hunky-dory, and the judge let it go? So that's what pisses me off about the whole phone schmozzle, shenanigans, whatever they fucking are. Because there are The damage is already done. They already, I don't know, what did they do? Hack into his phone? I don't know what they did. I don't know that I've heard Aiden say he didn't or did give them passwords, but I know Karen didn't. And I know I've heard Yannetti, I think, and Jackson both say no, Karen didn't give them passwords. So they still don't have access to her phone, so far as I know. But did they hack them already? I mean, we know Celebrite can hack them, so it takes a long time. It's just like sitting there on a machine the whole time, cracking numbers until it gets the code right. So we know that Celebrite can hack them, and it does take a bit of time. But they've had these phones now for what, 3 years or something? 19 months, I think, was the last time I heard. So probably 24 months they've had them for now. Let's talk about the little buddy boxing themselves in thingo. Let me find my notes on this because this is really interesting. The boxing themselves in notes are we've talked about that. I'm finding it. I'm getting there. Hold, please. Yeah, sure. Okay, I'll come back to that one because that's where I want to go next. Yep, that's the next thing I want to cover. So pass out. Here we go. This is kind of where it ties back to how do I explain this? The House defendants are boxing themselves in because they're doing this multi-front attack on Aiden, and then Karen and Aiden, and then Karen. But because they have to make different arguments in each of those attacks, and the arguments they're making, for example, in the in the defamation case, the arguments they're making in that case kind of contradicts the arguments that they're making in the criminal case. And then arguments that they're making in the wrongful death case, and even at the federal level, are contradicting arguments that they're making in both Aiden Carney's case and the defamation case. So I kind of wanted to sort of get into that because it's very deep how they're like contradicting themselves, but they're also boxing themselves in. So let me get the notes on that. The procedural. We talked about that. Where is it? Okay, that's where I got confused and had to research what the fuck went on with Kanani at the appeals court. I'm getting there, guys. Here we go. I found it. All right. So if they win the anti-slap, all right, I'm not saying that they will. I mean, we all know that they're not going to win it by Uncle Bev ruling on it. But there is a way they can win it, and I'll talk about that next. But let's say they win the anti-slap, then the next move from there is, so they got to pay damages. So they got to, no, sorry, the Massachusetts anti-slap allows them to be paid for their attorney's fees. But Massachusetts law prohibits double recovery. All right. So if Aiden and Karen were working together on the same anti-slap motion, and they basically presented the same anti-slap motion, then they couldn't claim separately for their attorney's fees. But what the plaintiffs have done, because that's the no double recovery law in Massachusetts. So what the plaintiffs have done is they have tried to keep Karen and Aiden together in the conspiracy defamation, but then Karen and Aiden have presented completely separate, even though they're both arguing petitioning, it's from two different angles. Karen's arguing petitioning as a defendant in a criminal trial, and she has a right to speak to the press or whoever the fuck she wants about her case. Aiden's arguing from a different perspective. He's always been, chasing down corruptions. He's covered so many different cases. You heard the arguments that attorney Pyle, I think his name is Pyle. You heard the arguments that he put forward. Okay, Aiden's been doing this for a very long time, long before Karen Read came along. So he's making a completely separate argument. He's making a petitioning argument, a First Amendment argument. He's making a whole bunch of arguments that are completely aside from Karen's right as a criminal defendant to speak to who the fuck she likes. So because they are so separate in their arguments, then that double recovery law doesn't apply. So Aiden taking this separate track actually helps Karen's chances, and his own chances of actually getting attorney's fees paid. But how do they get there? Because we know Gilday's not going to do it, but how do they get to that point where they're deciding how much attorney's fees they should be paid? So we'll get to that in a moment. So essentially what I'm saying here with the attorney's fees is that the plaintiffs have shot themselves in the foot because they can't bring Karen and Aiden together now under their single defamation conspiracy because they're claiming two different reasons for their petitioning activities. So they're going to be, if they lose, they're going to be paying attorney's fees for both of them, but it's their own fault because they're the ones fucking around with everything. So it is Pyle, Jeffrey Pyle, is that right? For Carney, and then it was Damon Seligson arguing for Read. So where do we go from here? All right. There's three roads forward from here, okay? Judge Gilday says, no, F off, we're going to court. We're going to trial on the defamation. Okay, fine. they go to trial, they find out the judge is an a-hole all the way through trial, like Arnie Bev was, and he tries to like limit what they're allowed to or not allowed to put into evidence, and fucking rah rah rah. We go through all that shit again. But that's the hard road. That's like the worst road. Slightly better road is, all right, do all of that, get to the other end, and go to appeal if you lose. That's another road. And, you know, the judge is making enough fuck ups just at the trial level, or just at the pre-trial level, that's a possible road. But here's the road that I think is the best road. I'm not a lawyer, so I'm not advising anybody. I'm just going, if it was me, I'm looking for the best road, right? The best road right here is Gilday completely fucks up the assignment, we'll call it. Let's say he completely fucks it up, and he rules on separating the Mura statements. That's interlocutory appeal. Everything goes on hold, no depositions, nothing. Everything gets stayed until Karen can get to the interlocutory appeal court and put his error in law before them. So that's a big fuck up. If he tries to separate or pass out the Terry Muir statements, that's a fuck up. If he tries to skirt the anti-SLAPP statute by saying procedural errors, that's an immediate interlocutory appeal. So once you get that interlocutory appeal, you can totally bypass recusal, asking the judge to recuse themselves. You can completely bypass that step and ask the appeals court to consider that he's already made up his mind about the defamation case, because in the wrongful death case, he said blah, 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 and accused them of all this shit, which is the main argument of the defamation case. So that's one way, and the easy way to get Gilday off the defamation case, stay the defamation case, have all of that put on hold, and have it put before another judge. If the court says, if the appeals court says it's not based on his judicial discretion either, it's de novo, it's regardless of his discretion, it's just, here's what the SLAPP law says, here's what he did, that's wrong, that doesn't follow the SLAPP law. If that happens, then the anti-SLAPP is automatically won by Karen or whoever takes it to the appeal court. It could be Aidan, it could be both of them. Either way, once the interlocutory appeals court, it's a big if, but if they do rule, hey, the judge fucked up, that's not what the law reads, here's what the law reads, they can add to that, we also want him removed, and it gets put in front of another judge. In that case, it's down, it's straight to, how much do these cunts owe you? Ooh, excuse French. How much do these guys owe you? And as we just discussed, that can now be divvied up between what they owe Karen and what they owe Aidan for their attorney's fees. So they kind of boxed themselves into these corners. They've also boxed Uncle Bev into that corner. He really has no choice right now but to dismiss, because any other choice from this point, according to the anti-SLAPP statute, like the current one, the Bristol Asphalt one, any other decision is a fuck up. As soon as he makes an error in law, that goes to the interlocutory appeal, and that's the fastest route. If you wait until the entire trial is over and then you appeal, you've just spent a lot of money on a fucking waste of time. So this is the fastest route to an appeal and to get it all sorted out early. So I think this is actually the better idea out of all of the options. Now, because I'm not an attorney, there's probably other options. Never had to fight a civil suit. So I don't know all of the options. I'm just like researching. And this is kind of where I come up. This is where I arrive at as probably the most fast track reasonable solution, the least cost for Aiden and Karen. I think this is the solution. And I actually think because these guys have been fighting the state for so long, they're both ready for it. Like they knew they were going to be up against the state. They knew there was going to be resistance. They know that they've got to get anything that they can out of these courts to appellate and out of state. So these are, out of the state courts. So these are the quickest ways to do that. So, sorry for saying the C word to those out there who don't like the C word. I apologize. I don't know. I probably just blew my monetization for the stream. But anyway, there's other ways they box themselves in. The houses keep doing this stupid shit that boxes them in. So some of the contradictory shit, right? For example, Karen, remember right back at the start in front of Uncle Bev, Karen's teams sort of alerted the court and said, we want to bring we want to join the Section 1983 claims to this motion and wrongful death because that's the substance of Karen's defense. And it's all the same facts. And Uncle Bev was like, you what? You need to put that in a motion. How dare you bring that to my court and alert me early that that's your intention. You haven't even told the other guys yet. And so they were forced to put it into a motion. No thank yous for letting us know early what your intentions were. And so that's how it got removed to the federal court, because the O'Keeffe's just straight away, as soon as it landed, went, nope, removing it to the federal court. And that actually separates Karen's defense in this wrongful death. Even though she can still argue some of those things, it narrows down what she can argue. Nonetheless, it makes it harder for her to fight the wrongful death if she's got to separate all these claims. Once they removed it to the federal court, it split off Town of Canton and Massachusetts State Police because they can't be sued federally. So now she's got to file another one. So that's basically broken the wrongful death into 3 different cases that they're all fighting on different fronts, because the MSP is Proctor's involved with all that shit in the Town of Canton. And then the federal case Proctor and the Hams are all involved in that shit. So they're arguing all these things on all these different fronts, but they have to keep contradicting themselves on each front because each front requires a different type of argument. I don't know if you're following me here, but they're bringing themselves undone like really quickly. So they're trying to weaponize all these different doctrines across state and federal, civil and criminal arenas, and they're creating like a tangled web of arguments that actually give Karen and Aiden a tactical advantage because they're only fighting one argument. Do you get what I'm saying? These guys are fighting 50 different arguments on 50 different levels to 20 different courts. And Karen and Aiden have only got one argument. That's it. There's corruption. Someone's trying to cover up Officer John O'Keeffe's death. That's their only argument. So they are frazzled trying to keep up with all the contradictions and their legal implications. So in the federal removal, when the O'Keefes removed to the federal court, they basically put the House, and I'm sure the House defendant was like, "Yay!" Except now they're in a flip flop, because they could have claimed the anti-SLAPP just to dismiss if they'd have kept it in. If they'd kept everything in state court, the anti-SLAPP would have been the easy way out for them. But they removed it to the federal court, and now they're trying to argue anti-SLAPP. That's a state statute. That's not federal. So they can't claim the state level immunity protocols should apply in a federal forum that they insisted on using to escape the state court. Does that make sense? Furthermore, by asserting that the witness testimony is protected petitioning, they are validating the broad definition of petitioning that they're arguing against in the defamation case. So they're trying to say that Karen can't have that argument in the defamation case, that she was, petitioning for her own case, or her. It's like witnesses and anyone testifying in a court hearing, that is broadly protected. I think it's 100% immunity if you're testifying as a witness, or if you are making your own argument in defense of your own innocence or whatever. That's all protected activity. So what they're doing is they're arguing that for themselves in the federal court, but arguing against it for Karen in the defamation court case. And then the biggest logical failure in the defamation lawsuit is that their formal complaint sues Karen and Aiden under the theory of civil conspiracy, claiming they worked hand in hand as a unified, coordinated unit to defame the families. But when it came to the July 14 arguments against the anti-SLAPP, they completely separated the merits. They were like, well, no, Aiden Carney was doing this, this, and this, and this, because I can't really attribute everything that Aiden was doing to Karen Read, right? So they had to argue his separately. And then they had to argue that, Read's Terry Muir statements, which Aiden has nothing to do with, he wasn't there, he didn't encourage it, he had nothing to do with those statements. They were separating the merits, slicing Read's Hollywood interviews away from Carney's blog and merchandise track. So you see the little conundrum they got themselves into there. So they like trying to have it both ways, right? So if it's a unified conspiracy, then any protected petitioning naturally shields conspiracy as a whole. So by explicitly separating the merits, trying to bypass the Bristol asphalt, they're effectively dismantling their own conspiracy claim. Yeah, follow? I don't know. I need to look at the chat and see if anyone's following this, because it's complex, but they're actually undermining themselves by having split all these things off into different court cases, criminal, civil, federal. They are finding it hard to make one coherent argument. They have to keep contradicting themselves, because each court and each level of decision attracts a different set of rules, okay, a different set of laws. So like in the federal court, here's another example. In the federal court, the federal judge doesn't have to stick with the straight up two question, was it petitioning and was it legally supported and factual. The federal judge doesn't have to stick to that, because it's a state statute. The federal judge has a completely different a different way. So the only way a state statute can hold up in federal court, there's one lane or one avenue or one consideration that the federal court has to make. And I'll come back to that because I freaking forgot what it was all of a sudden. It's ping, fell out of my head. hang on. I'll come back to that in a second. So the federal court, I'm just going to pull up what that is, but the federal court has a different standard to decide whether the anti-SLAPP can be used in federal court to slap down a federal court question. And it's one specific avenue, and that's it. Otherwise, state anti-SLAPP does not apply to federal court. I'll come back to that in a second, what that avenue is. But Judge Gilday, Uncle Bev, he's only got the state, he's got to stick to the state statute. Okay, he has to ask the two questions: was it petitioning? Does it have a legal and factual basis? That's it. If he doesn't rule those, he fucks up, they lose. If Casper if Casper looks at it and says, look, I will let you be protected from the SLAPP, she can pass it out and divide it up because it's federal law, and some of it falls under federal law and some of it doesn't. So she can say, all right, the federal law protects you for being witnesses. So anything that you said in testimony, you're covered for that. You have 100% immunity from that. But anything that you said prior to trial, any of the cops that you spoke to set Karen up, all that sort of stuff, pre-trial and pre your testimony, any of that shit, that comes in because that's not protected. And that's exactly what the argument is that Karen Read's presenting to the federal court. So not necessarily that their witness testimony is what framed her, but all of their activities before the witness testimony is what framed her. So hello, Rose. Thanks for joining us. So that's what that is. Now, let me just go. What's the federal decision? The federal decision is she most likely. Where's Casper? Come on, where's my fucking Casper notes? Okay, the paradox of the bifurcated claims. The plaintiff's in the wrong. This is some of the stuff that I wrote. Okay, just got to read it out so I can find where the hell I'm up to. The plaintiffs in the wrongful death suit thought they were pulling a brilliant tactical maneuver when they severed her defense and removed her Section 1983 civil suit to the federal docket. They did it to strip the state-level proceedings of the federal expert testimony. That's what I'm thinking. So the ARCA guys. But the funny thing is, I think Casper can actually get hold of, you know the shit we haven't seen that the feds have got. You know that shit? She can actually ask for that shit because she's got privilege to see it. The only reason the two tracks are separated is because the plaintiffs themselves forced the split by running to the federal court or by encouraging the O'Keefe's to push it to the federal court. And then Auntie Bev blaming the defense for the fractured procedure that the plaintiffs engineered, exposing his total lack of impartiality. That was another funny little sort of backfire there, because they put Judge Gilday in a position with that whole situation, because now he knows the federal court is going to be watching what's going on. So what a tangle web we weave when we first practice to deceive. Indeed, pork chop. Indeed. Indeedy. And she cheat. All right. So federal judges do not answer to the Norfolk District Attorney, nor the local politics or the tight-knit Massachusetts judiciary. So in the federal Section 1983 suit, they're going to be hunting the systemic corruption of the MSP, the Canton Police Department, the DA's office, and all of those people involved with that, Proctor. The whole lot's going to come out in the federal matter. But that's probably going to be where the reckoning happens, at the federal level. Because they can't pull all this shit. They can't pull all this, arguing against themselves and contradicting themselves in, 5 different cases. They can't pull all this in the federal court. It's big pork chops, sorry. Big. So little pork chop is your daughter. Gotcha. Sorry, big pork chop, no worries. All right, I need to wet my mouth. Give me 1 second. I'm going to mute so that anybody who has auditory problems listening to me slurp doesn't have to listen to it. Oh, please. All right. All right. Now, I have to wonder how much of DA Morrissey's emails are going to come into this. So remember, pre-trial 2, I think it was, pre-trial Karen Read 2, David Yannetti stood up in court and said all that stuff about Michael Morrissey's burner. And then Michael Morrissey's burner had incriminating stuff in there about him manipulating judges and all sorts of shit going on in the background. I have to wonder. So what happened in that hearing, just as a refresher, Yannetti said, hey, we got the burner. We saw some of the burner stuff. We want access to it. And Hank Brennan didn't object. And Auntie Bev didn't object. She went, yep, you can have it. But then she assigned the DA as his own fucking team. So clearly they were going to cover shit up, right? Nonetheless, I think there's more information we haven't heard yet. They decided not to use that in the trial and to just go straight. Karen Read's car didn't hit John O'Keefe, and John O'Keefe did not hit Karen Read's car. They went straight with that. So there's a lot of stuff in the TUI materials and the Morrissey burner emails, I think, that still hasn't come to light yet. So in the federal case, all that's going to come out. I don't think they're going to be hiding it this time. So because they're claiming malicious prosecution, there's 2 claims they're making in the federal court. Malicious prosecution and, that includes, violating her rights. And then there's some Monell claims. The Monell claims are like, I need to refresh my memory on what one all is, but it's something along the lines of, is this a policy and did they follow the policy or did they not follow the policy? So if it's a policy and they didn't follow it, then whoever it was that didn't follow it becomes personally liable for not following the policy. If it wasn't a policy, then the officials of that policy become liable, if that makes sense. I think that's how Mona works. And I think what they're aiming to do there is to make Proctor liable. So, the Erie Doctrine. Okay, this is where we're talking about the Housos want the federal case dismissed using the anti-SLAPP, but there's only one narrow lane that CASPR can entertain regarding the anti-SLAPP application, regarding the state anti-SLAPP's application to federal court. So, whether it applies to federal court is probably the better word. So, applying anti-SLAPP in federal court, because it's a state statute, remember, is one of the most contentiously debated procedural, battlegrounds in American law. And CASPR has like this really narrow lane that she's allowed to navigate it in. So I'm just formulating my thoughts as I'm looking over my notes here, so I can say it in sentence form and not note form. So the Erie Doctrine is what I believe Reed's team are arguing. So under the Erie Doctrine, the federal courts must apply state substantive law but follow federal procedural rules. So substantive state law but procedural federal rules. So the First Circuit Court of Appeals has carved out this narrow boundary regarding how state anti-SLAPP rules can interact with the federal lawsuit. They ruled that, there's a First Circuit, the state anti-SLAPP statutes can't disrupt the standard federal rules of civil procedure. So specifically rules 12 and I think 56 off the top of my head. Those govern, standard motions to dismiss. I think 12b6 is one of those. and summary judgments. So a summary judgment is like also known as a state of batshit crazy. It's so funny because I do have a batshit crazy couple of comments coming up. This is in Massachusetts, the state of batshit crazy. Oh no, not Erie Doctrine. Yes, Erie. Sorry, slap. For those who want to know how it's spelled, Rose has in fact spelled it correctly. So basically the First Circuit ruled that, there's this very narrow lane which state anti-SLAPP applies. In Massachusetts, in a Massachusetts state court, following an anti-SLAPP motion automatically freezes discovery, but in Judge Casper's federal courtroom, that automatic state level procedural freeze doesn't apply. So that's the other sort of like side effect, I guess. The federal track keeps moving forward under standard federal scheduling. And then the narrow lane, to break it down a little further, is that Casper can entertain the anti-state statute in a strictly substantive analysis. She can't use the procedural shortcuts or the all or nothing shifting burdens of Bristol asphalt that we were just talking about in the state court to throw out the case at this stage. Instead, she can only look at whether the underlying claims that Karen brought against witnesses into the federal court, such as civil conspiracy or malicious prosecution, are completely legally deficient because the witnesses' actions, either testifying or speaking to the police, were protected petitioning activity. All right. But here's where it fails, because all the shit they did before testifying, all that conspiratorial shit they did before they testified, yeah, that all still counts. That's not immune, and it's not petitioning activity. So I just wonder if I have to explain it, a couple of different ways, backwards, forwards, and upside down, just so we understand what it is that we're trying to say here. So because the federal rules are higher bars, let's say, for a defendant to hit, the House's argument that Reed's civil rights lawsuit is merely an act of revenge or a conspiracy telephone game is going to face a lot heavier scrutiny. And it sounds like that is actually what happened with Casper in that motion on the 14th of July. So while Uncle Bev in state court is playing with procedural technicalities to try and protect the plaintiffs, Judge Casper is bound by the federal pleading standards. So under the federal 12b-6 rule, Casper must assume, it's must, not may or could or maybe, it's must assume all of Karen Reed's factual allegations, including the coordinated manipulation of the investigators, are true for the purposes of deciding whether the case moves forward. So that's the difference between Casper's decision making and Gilday's in the state court. And because Karen's federal motion, heavily incorporated, unredacted federal grand jury testimony and independent forensic evidence directly into, baked into her complaint, the Houses can't simply hide behind the anti-SLAPP to make it disappear, because that was not them testifying or petitioning. And if I'm reading into it correctly, listening to Grant Ellis Smith, I can't remember which way his name goes. Listening to Grant talk about what happened in the federal court, it sounds like Casper was skeptical about some of the expansive civil right links. But because the federal standard is completely divorced from Uncle Bev's local sandbox, the Houses can't manipulate, that docket the same way they've done in Uncle Bev's sandbox. So the state plaintiffs tried to gain an advantage by splitting the dockets, but they have ultimately walked into a trap. They are trapped by Bristol asphalt in a state court and trapped by strict federal discovery rules under the federal court. So that's what I'm trying to get at. Okay, they keep trapping themselves in these stupid little contradictions because they're just trying to do too many things at once from too many different angles at once. But that's just a couple of examples of how what they're arguing in one court, they're trying to argue against in the other court. we're deserving of having our witness testimony, being a protected activity, but Karen's not, even though she was actually a defendant. So it goes on and on. These are the funny things that they're doing to themselves. They're the ones that broke it away from the federal court and created the federal argument and did all this shit. They're the ones that I don't know if you guys are aware of this, but there was one court hearing just recently. Well, it wasn't recent, but it was one a little while ago now, probably close to 6 months, maybe 8 months ago. In Aiden's case, where Cozzy Bear stood up there and told Judge Belazos that, look, it's just too expensive and time consuming to do a defamation case against Carney. So, Your Honor, we had to charge him to make it cheaper for them to stop him from doing all this shit. That's what he said in court. I'm paraphrasing, but that's basically what he said. He admitted that they're only charging Carney to save the Halzos from a defamation case, who turned around about 2 months later and filed a fucking defamation case. Work that one out. Anyway, that was the point where I realized Belazos was crooked as well. You cannot tell me that a legitimate judge is going to sit there and listen to the prosecutor say, this is really a civil case, but we decided to charge it criminally to save everybody some money and, charge it to the fucking taxpayers. I don't believe any judge in their right mind is going to sit there and listen to that shit and go, yeah, no, we're dismissing this. And not go, we're dismissing this. But I think you knew what I meant there. But that was when I realized Belazos wasn't going to be doing anything different, but sticking up for the state. So, where do we get to Crazy Town? Where did we get to Crazy Town? I think that's it. I think we're at Crazy Town now. So we're at Crazy Town when Cosgrove says to Judge Belazos, we only did this so that the House defendants don't have to go through the time and costs of a defamation case. And that's where this should have all ended. But no, now he's still sitting there trying to argue, no, this is definitely criminal. Even though Cozzy Bear told us it's not, it's definitely criminal. So let me just go through one last swoop through my notes, make sure I talked about everything connected all together. All right, so anybody confused about how this all connects together? Because I think I'm there now. I think I drew all the lines together so you can all see that this is just all state actors. This is all the state apparatus being used against Karen and Aiden. But they are actually in the they've got the advantage here, because they're only fighting one thing, that all this is state apparatus corruption. And the more they try to do it, the more they try to do all this screwing around, the more they're proving it. Whereas they have to contradict themselves, because they're arguing so many different fronts, different arguments, trying to make something work and stick somewhere. So, and I think that's why Uncle Bev ruled that he won't let them use their depositions in these two cases that he's presiding over in any other cases. he actually doesn't get to make that choice. He cannot tell another judge what they can or can't do in their court. But that is what he ruled the other day. He was like, well, most of this stuff you can use in your other cases, but these things here, no, these things here, they stay here in my court. We can't use them elsewhere. So I kind of feel like he sliced and diced that a little bit too conveniently. But you can tell, because he did slice and dice it that way, that he's still trying to protect the state, essentially. So that's how the state apparatus, the entire state apparatus, including the courts, are being used against Karen Read and Aidan Kearney. And you can love him or hate him. It doesn't change the underlying facts. Like, nothing I said today says I like or dislike him. Everything I said today is just based on how I'm interpreting what should be the process. Except this is fucking Massachusetts, and nothing works how it's supposed to in Massachusetts, including physics and phones and shit. So so when do we expect, this is the last thing, when do we expect people to be making decisions? So I believe 60 to 90 days for the federal court. There's no particular rule, but this is the typical time that they would take, is between 60 and 90 days for Judge Casper to come back with a written ruling. So we can expect that, I guess, around mid-September, mid-October. And then looking at the average sort of time for the state courts to rule on things like anti-SLAPP, probably 60 to 120 days. I get the impression that Uncle Bev's probably going to drag that out to as long as he can. So I expect to see Casper's motion before his. And I could be wrong. I'm just guessing here. He might actually be in a hurry to rule, just because he wants to protect the houses. But he might not. He might just drag it out to. So I'm in at one side of his face, he's saying, like, I don't want this to cost everybody too much money, so we need to get this over and done with very quickly. Let's get, August is when he wants all the depots done. He might try and rule. He might actually stick to that and try and rule before, August, before depots are all done. But ever since those anti-SLAPPs were argued, nothing can be done. Everything's frozen now. No one can do the depots in the defamation case. No one can do discovery in the defamation case. So that's all on hold because of the anti-SLAPP. That's the automatic freeze that comes with anti-SLAPP dismissal. So those are the dates. So if Gilday comes back and he fucks up, makes an error in law, then Read has 30 days. Read and Aidan have 30 days. Karen and Aidan. It's already written his going to hold it until the last day he can. Yes. I suspect so too, Big Pork Chop. But he might put his money where his mouth is and try to move this along so he can get that August, deadline happening. So we'll just see. We'll see where he goes with that. He'll surprise me greatly if he hurries it along, because he's genuinely worried about it costing everyone money. So he will surprise me greatly if he does hurry it. If he does make an error in law, then an interlocutory appeal is 30 days. So whilst the judges don't really have a time limit, everybody else fucking does. But that's the time limit for Karen and Aiden to appeal any errors in law that Uncle Bev makes, and then in that appeal that freezes everything as well. Nothing else can go forward until that appeal is heard. And then in that appeal they can also make the points that he's already decided Karen's team is leaking to Aiden Carney over this whole fucking stupid timestamp mess up in the wrongful death case. So he's already showing that he is he has the appearance of not being impartial. He's already established that. It's on the record. He said it in court. He brought them all in and blasted them. Like, you can't hide any of that shit now. So that can all be brought up in an interlocutory appeal if he makes an error in law on this defamation case, because his impartiality that he's showing in that case crosses over into this case. That's the link between the two. Normally you wouldn't be able to say, oh, well, he did that over there in that case. In this case, the link is the impartiality is the very basis of the defamation. So that's how those two tie together. So if that happens, like I think I think Seligson and those guys, even though it looks like they're not fighting the judge, this might be why they're not fighting the judge. They might be like, yeah, fuck it up, go for it, because we've already got our appeal written. You can expect an appeal no matter which way he rules. If he rules in Karen's favour, yes or no, highly unlikely, but the Halzos will appeal. Right, but the Halzos have got way less chance of winning appeal because Karen and Aiden's anti-slaps are actually pretty straightforward. They are pretty straight. They pretty much answer the very two questions that they have to answer. Like, even if you only partially answer question 1, you go to question 2. And even if you only partially answer question 2, you still get dismissed. That's the way it works. So, Karen's got a better chance of winning an appeal than the Halzos do. I think that's it. A lot of people are saying, Uncle Bev's going to drop his ruling, significantly sooner than the federal. I don't think so. I don't think so. I don't have any faith in him whatsoever. I feel like he's just fucking with everybody now. He's just gaslighting us all. True big pork chop, and that is another layer to the cake, isn't it? Because we already saw the SJC favoured Auntie Bev in the last appeal that Karen went to the SJC with. So we already know they have a little bit of favoritism for the judges, even if it is de novo. So we're not in Kansas anymore. We're in fucking Massachusetts. All right. Anyway, that's my rant. Anybody else want to have a rant? Go for it. Say your piece or forever hold your tongue. No. Hopefully I explained all of that very, very clearly, and you understand where I'm coming from. They all tie together in exactly all those ways, and the Halzos are completely fucking it up. Even though it looks like their lawyers are so bigwig talking fancy shit, their lawyers are fucking it up. Because remember, it's that bigwig fucking lawyer who won a default against Alex Jones, who stood up there in the state court and said I forget what he said. Oh, that's right. And said that Karen Reid's petitioning activity should be separated into these two different baskets when the new anti-slap law says you specifically cannot do that. So, and everyone was like, oh my God, he's so good. And I'm like, no, actually, he's not good at all. He's doing the exact opposite of what the anti-slap statute says you have to do. So he says it. He says it with confidence and with gusto, and people are like, "Ooh, that's good." and Seligson standing there going, "You know what, Judge? If you want to fuck up, yeah, let you fuck up. Be our guest." And that looks not confident and gusto. That's quite the opposite. If you understand where this is going, then you can kind of see what Seligson was doing there. I'm not going to argue with you too hard because we got this one in the bag. And I think they do. But they had to actually lure Uncle Bev into that trap. If they don't lure him into the trap, if they're quite obvious about it, and I'm probably not helping because I'm out there going blah 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 blah, telling everybody, I'm probably not helping. But yeah, if he walks into their trap, if Seligson doesn't do too much fighting and like lets him fuck up, that's where I think we're heading. Straight into an interlocutory appeal, puts it all on hold. Karen's free to fight the other shit that's going on, get the depots done by August for the wrongful death and all that sort of shit. So we'll see. We shall see. We don't have enough time for my rants. Good on you, big pork chop. Thanks for the safe place to vent. As always, you guys are the best. Good night, Older Than Dirt. Thank you so much for joining us. All right, I'm exhausted. That was 2 hours. 2 hours well spent. Does anybody feel better after that? Like, just knowing that the Housos keep fucking up their own stories. I know it doesn't look like that right now, but this is all going to fold in on itself. Ultimately, once the defamation suit is off and running, that's going to fold in on itself. If it doesn't go to interlocutory appeal and get knocked down, it's going to fold in on itself. If this plays out in trial, it's going to fold in on itself because another jury isn't going to buy any of this shit. Have you checked out the body cam footage at all from our old friends in Utah? Speaking of self-fucking up. All right, let's talk about Reckless Ben. There's a couple of things I want to say about Reckless Ben. Seems to be a lot of people trying to encourage Reckless Ben to sue American Fork Police Department. But here's the thing. I don't get the impression, I could be totally wrong because I don't know the guy from Bar Soap Radio. He could be two completely different people, like from his online persona to his actual persona. I don't know the guy. But I don't get the impression that Ben's chasing $1 million or a couple of $1 million. I get the impression he just wants to see the right thing done and he'd be quite happy with a chicken dance. So, and that's the type of person he comes across as. I don't know if he's really like that. I guess we'll find out. But I don't hold it against him because I'm kind of like that. If you gave me the choice of suing the police department because they fucked something up or making them do a chicken dance because they fucked something up, I'd go with the chicken dance every fucking time, even though I need the money right now. But I'm kind of like Ben, like, you know, I'm not just going to sue people because I've got a penchant for money. I don't. I can get by without money. I mean, I've been doing it for fucking most of my life already. It's not going to make much difference. Sure, everyone wants to retire on some, pretty little paycheck or whatever. but I think I'm more like Ben. Like, I would just rather see the chicken dance. And a lot of people are motivated by money, and I ain't holding that against them. But there's quite a few of us out there who are not motivated by money. So how hard you want to sue someone, I think, comes back to how motivated you are for the money. Because there's a lot of stress involved. I mean, look what Karen and Aiden are going through. It's a lot of fucking stress. It ain't easy suing the police department and fighting the entire state apparatus. Like, I heard he doesn't really care for money, but also if it can be demonstrated that they will not change their ways, then prison is an acceptable consequence. I agree with that. He also thinks that a stipulation that the town can get its name changed to Reckless Benville. I heard that. I was listening to that. Someone said that. Someone said that on there. So they had a live show and people were calling in, and they were like, "Really? Like, just a chicken dance? Can't we just add something to that?" He says, "Yeah, okay." You got to change the town to Reckless Benville. So yeah, I don't get the impression that he's a money person. He's not going to try and sue everyone. I mean, he could, and you can see the merits of, how much he could win if he wanted to, but he could be fucking bothered. It's like, I don't know if it was a couple of $1 million. I can see why some people would be tempted. Let's put it that way. You know how they say, well, you couldn't pay me $1 million to go through that fucking stress. Yeah, it's a hard road. It's a hard slog to earn your million, that's for sure. And then, you're fighting against one police department and the entire fucking state decides, oh, yeah, we're all going to just jump in on that, which is what is happening with Karen and Aiden. So, so that's it. I think I have flogged the dead horse as much as I can. I don't think I've got anything left. Oh, Ben, hang on. Wait a minute. Rose was asking, have I looked at those videos yet? And Rosie, I have, but I haven't yet. I've pulled out a whole bunch of stuff from the video so far, but I haven't, because I'm still working on some other things with the Karen Reid case. I can probably show you what I'm working on. Maybe not. Yeah, I can't show you because I just fucking pulled it all down. Unless you're Dan McNeff, then it's hard to keep your million. Right? The only thing you ever had to do was shut the fuck up. This is true. So, Rosie, I promise, give us a sneak preview. It's kind of like what you guys did on your map. Hang on, let me see if I can kick it off. Give me a second. This is just a fuck around because I just took it all down for a specific reason. Let me see. Let me see. I've got to think about how to bring it back up. I'm going to have to change a couple of lines of code to do that. I was in the middle of doing this and I was like, I'm going to be late for my stream. So let me find it. Yes, this way. But it's got all these fucking backslashes in it. All right. I shall show you. So Rosie, how you guys did the I don't know, is it a graph on your website? And then You showed where all of the muted or the edited you showed where all the muted or the redacted portions of the video were. It's kind of that sort of concept, but it's a little bit more deeper than just where the redactions occurred. I haven't even got to that part yet. So let me just check this is right. All right, so now I've got to check that this here, take that out, run this script instead. Let me just check it's all right. What? No such file or direct. Oh, shit. I have to jump out of there. If I'm free. Source viewer. Oh, there's a duvlaki on the end there. That's what it was. Oh no, that's not it. Oh, fuck. Oh no. I lost it. In source, maybe. You'll like it when you see it. I've actually shown my audience this once before, so they're probably sitting there going, "What? You made us sit here for all of this, and we already knew what you would." But Rosie will appreciate it. Trust me, everyone. Oh, it's frame analyzer there. That's why. Okay. Source. I'll never complain about having to wait. Cool. Everyone else is going to sleep on me. Oh, bitch. Okay. What's it fucking complaining about? Cache. AV container. AV error. All right. Sorry. Can't do it, Rosie. Sorry. It's hard to explain too what it is. So it's like a complete forensic breakdown of every single video. So it'll do one single video, complete frame breakdown, packet structure, frame structure, null unit, scan, data, header data, metadata, everything into a database, and then putting it into a PyQt viewer with PyQt graph and all this fancy shit to view all of that data, but visually, to help lawyers work out video forensics. This is mostly video forensics, but I'm going to expand it a little further into image and audio. I learned a little bit about the audio and the image side of things while I was at it. But I've been crash coursing video data, but the GPS data and the accelerometer data and all of that that are in the Axon files is going to go a long way towards, well, there's a couple of different uses for it. There's so many things I can do with it. But in the case of like the video streams, I just need that for the comparison. So I get another dash cam for another case, and I want to know, does that dash cam footage look exactly like today's version or current version of Axon output? And so what you gave me was the two types of output from Axon. You gave me the original unredacted, and then what the redacted stuff looks like. So I've got the fingerprints of both now. And so now I can actually say, given this video, is this genuine Axon video footage? Because now I've got the fingerprints and I can look at it and go, nope, those are all not Axon fingerprints, which is what I expect to happen in the Karen Read case. And possibly the Turtle Boy case, although I don't think there's too much. There is some police footage actually in the Turtle Boy case. There actually is. So, and what I found was, like, because we FOIA'd the DA's office to find out what software they use and what their body cameras and dash cameras run on. So I thought originally it was Motorola. I was just trying to match up, the view we got, which was multiple different views. But I was trying to work out whether it was Axon or Motorola. And then when we got the FOIA back, it was Axon. So now I know it's Axon. That's why. So your fingerprints will help with all the cases. So I will send this software to anybody who wants to use it. Okay? Anybody who's stuck in a legal situation, anyone who needs it is who gets to use it. So so it's not robust enough to decode muted voices from vibrations. No. Muted voices from vibrations. You're cracking me up here, girl. Did you look at the band map thing? There is a similar new thing. You got a new thing on the band map. No, I haven't had time to scratch my ass, man. Sorry. Hooray for open source. Exactly. Yeah, so I wish I could just show you, a little sample of it, but I took it all down today. I started recoding some things. So it's got like a few errors in it because I'm like in the middle of something. There's like a half-finished line waiting for me to get back to it. So I couldn't get it back up for you. And then I would have to sit here for at least an hour go, where the fuck was I when I started writing that line to finish it and bring it back up again. So I'm sorry I couldn't do that. But come back next time, because by the next one, I'm like this close. I'm like this close to having a full interface ready to look at. I've got my actual design like sitting on the screen. Just, I've got a light mode, a dark mode, a good color scheme happening for both. But yeah, none of it's connected to like the actual software yet. So is there any novel info you have found so far other than the actual Axon fingerprint? And I haven't had time to look any further into it. So, but I want to go check out your new feature on the band map just to see what you're playing with. It's good to watch what other people are doing with their Python scripting as well. I'm not a Python scripter either, by the way. I had to like crash course it. I actually can write code in probably 12 different languages, depending on what you want to do. Everything from, raw SQL through to JavaScript. and back end server type stuff. But I never got into Python. Like I was always Windows, and then about 2 years ago, I started. Someone offered me. Someone offered to buy my fonts. So I made some school fonts, and I was putting them out there for free so that all the parents could have them for free. And then someone from Google rang me up and said, like, can we have your fonts? And I was like, yeah, nah, because I don't trust you guys. But he spent like a long time lobbying me for those fonts, like over a year. And eventually I gave in. I was like, look, you make sure I don't have to jump through any stupid Google hoops and NDAs and all that fucking crap, and I'll sell you the fonts. And so he did. So part of that was I had to use a specific for open source times 2. I had to use a specific software called Glyphs app, which only runs on Apple Mac. And he's like, you're gonna have to get yourself an Apple Mac, so we'll add $5,000 to your bill and buy you an Apple Mac as well. So I got onto the Apple Mac, and I was totally lost because I've just always been a Windows programmer. And it's just been this last couple of years I picked up the Apple Mac. I had to learn how to speak ZSH crap. Pretty much only Rose will know what that is. But yeah. And now I'm doing a bit of Python coding, learning the Python. I bet they were already accidentally using them, and they were trying to get you a retroactive permission so they wouldn't get in trouble. No. He was dead set serious. He wanted to buy it and pay a lot of money for it too. Hence why I'm building a house. So, but yeah, it was a full suite by the time we got to that point. It was a full suite of fonts. In fact, I can chuck it in there. Let me see if I've got them all up yet or not. Hang on. How about you don't do that, stupid? I'll show you my fonts. Yeah. Edu. Whoops. Just the EDUs. Was that one of mine? Nope. All right. I know there's a whole bunch of them, so there's one for every state, but here you go, Rose. There you go. Have a look at that. I don't know why it took me so long to freaking find them. You'd think I'd have them bookmarked or something, but no. That's just one of the fonts. There's Queensland, New South Wales, South Australia, and 7 of them. There's 7 we've actually got more than 7 states, but there's 7 fonts. But yeah. So now all the teachers are using them here in Australia, and all the parents get them for free. That was the other deal. I was like, yeah, I'll sell them to you as long as I don't have to jump through any Google hoops. And parents can still use them for free. And they agreed to that. So, and parents are still using them. It's still there for free. So I was pretty pleased with that. I didn't expect them to stick by their word, but they did. So I was pretty pleased with that whole thing. So all the schools, because here in Australia, I don't know if it's like in America, but here in Australia, you had to pay, it was over $100 for your kid to use one school font, essentially. And it was a subscription too. Like, it wasn't just you pay for it and then you've got the font. You had to pay a subscription. So, you know, parents who couldn't afford that $100 were just like, you know, barely able to even afford a computer. So that was my deal. You know, as long as the parents are still getting it for free and the kids can still use it, I'm quite happy to sell you the fonts. And now they packaged them. Did you get to choose the sample text? No. No, I didn't. That's their standard. That's their standard text. They change it every now and again over there on the Google Fonts website. Pardon me. Did you like what it said? Hang on, let me read what it says again. The recognition of inherent dignity. No one shall be subjected to arbitrary arrest, detention, or exile. Everyone is entitled in full equality to a fair and public hearing by an independent and impartial tribunal in the determination of his rights and obligations of any criminal charge against him. No one shall be subject to whether aren't Google. Hey, why aren't Google using their pronouns? No one shall be subjected to arbitrary interference with his privacy, family, home, or correspondence, nor to attacks upon his honor and reputation. Everyone has the right to protection of the law against such interference or attacks. Sounds like Google's doing some, what do you call it? Activism, which doesn't surprise me. I don't have a problem with that. But no, I didn't get to choose the text. Anyway, that was why I ended up with a Mac laptop and learning Python. Long story short. So I'm very new to Python. I'm still getting there. I still need a little vibe coding help. Lobbying, yeah, that's it. All right. I think I'm just about done. Rose, I promise you, the next live stream, I will have some more news on the bend front, like what I'm doing with the files on the bed front. So what I'm trying to do right now is get those Axon files incorporated into my interface, into my user interface, so that I can do comparisons. As soon as I've got a comparison happening, does this video look like an Axon video? I can show you the result of what you gave me. Because I do have dash cams that I actually know are not Axon, even though they're supposed to be. So I've got some really good, worst case scenarios to show you. But yeah, I promise I'll have something the next time I go live, because I'm like just so close. I'm like probably 20 lines of code away from having it all connected up and happening. So if I wanted to rush it or vibe code it, I could, but nobody likes vibe coding. So we'll see how we go. Thanks everyone for watching. Excuse me. And I'll catch you all in the next one. I think there's only Rose left. Thanks for joining us, Rosie, and anyone else who is still watching. And we'll talk to you on the next stream. Ciao.